Hi, welcome to Conversations with Care Navigator, aka Mondays with Maureen. My name is Stephanie Wilson. I work in the Four Seasons Foundation, and you may recognize our guest today, Koral Alman. She's been a guest on Conversations with a Care Navigator several times over the last couple of years. Koral and I are covering for Maureen Williams over the next couple of weeks as we focus on various aspects of estate planning. We know this topic can be misunderstood and sometimes a little intimidating for some folks. So Coral and I hope that we can simplify it for you. Um, Before I dive in, I want to say a big thank you to the Winkle Law Firm for being our title sponsor of Conversations with a Care Navigator. So Coral, welcome back. Can you tell the audience a little bit about yourself?
Sure. Hi, Stephanie. Yes, I'm Koral Alman. I'm a partner with the Winkle Law Firm. I'm also the foundation chair for Four Seasons, and I'm grateful to do this today in Maureen's stead. I always like to say at the top of this that I am not your attorney and that this is not, we've not created an attorney client relationship, so you need to confer with your own attorney about any of these things, but just giving general guidance about this sort of topic. And I think today we're going to talk about the importance of a will, right, Stephanie?
Yes, we are. Thank you. Thank you. Well, let's dive right in. So, Coral, can you share with everybody why having your wishes legally documented can be such a gift to your family?
Yeah. So if you don't create a will, the state of North Carolina or whatever state in which you reside creates one for you pursuant to that state's intestate statute, which is usually the state legislature's attempt to come up with either the best, fairest, or most logical plan, but it often fails in all three of those regards. Um, People sometimes think I don't have enough money to do this, or I don't, it's, I'll deal with that later. But the reality is, we don't know how long we get. And one of uh, truly the greatest gifts I've seen parents or people give their loved ones or children or whomever is guidance about what they want, both in terms of what is in their will, where they want their assets to go, who they want to be in charge of those things, but also giving guidance about funeral arrangements, end of life care, all of that sort of stuff. The clients I have that do best after losing a loved one are the ones who really know what that loved one would have wanted. Either because they have a will that provides the terms and guidance for that, they have a letter that that person wrote to them, or even better, they have both of those things and they have had a conversation with their loved one while they were alive about end of life care, who should get what, etc. It really just gives people a lot of peace of mind to know what the actual plan is. As long as your will is validly executed and provides clear guidance, it really helps people out.
Okay, thank you. Can you go into a little bit more about what you mean by validly executed?
Yeah. So I've been doing this for 10 years. I've been practicing attorney for about 15, but estate planning exclusively for about 10. And in that time, I have seen many people who have made wills at home, done them themselves, tried an online service. And I am not saying you can't effectively create a will that way, but I have not really ever seen it done personally. In my personal practice, a lot of the wills that have come through that were homemade in one way or another have problems with them. Either in terms of its execution, there are statutory requirements as to how a will needs to be executed, witnesses, notary, whether or not it is self proving. All of those things are pretty formulaic, but if you fail one of those tests, you've got a problem. Another thing people tend to do is they will have a will drawn up and then they cross things out and write in the marginalia, actually, I want this to go here or this to go there or whatever. And that can create some problems. Or people just don't do anything. I've also had many clients who will say, oh, I've got 3 kids. I'm just going to put my daughter, it's always a daughter for some reason, as the beneficiary on this bank account. She'll gift it she'll make sure her brothers get what they're supposed to get. And you are creating a situation ripe for conflict. You are creating a taxable gift potentially for that daughter to make to her siblings. You are creating unnecessary problems Whereas you could have a will that just says everything equally to my 3 kids that a lawyer could drop for you.
Sounds like a pretty simple solution to avoid some mess down the
Yes.
road.
Yeah.
What happens when somebody dies without a will?
Yeah. So there are ways to handle assets without a will that work, but sometimes you have to think about them as part of a global plan. So sometimes you have things governed by joint ownership within a bank account, such that title to that account will just transfer automatically to the joint owner. You can have things governed by beneficiary designation, so that at your death, that account just transfers equally to your 3 kids. But if you don't have those things and you don't have a will, or you have those things and you receive an asset after your death that's not covered by those things, right? Like you've prepaid 6 months of an insurance premium and you die in that first month, you're going to get a check back for 5 months of that overpayment that you'd already sent. That check is coming payable to you or your estate, and the only way to deal with it is via an estate with the probate court. If you have a will, that money will go where you want it to go. If you don't have a will, the intestate statute will direct where it goes. The example that we often give when talking about the importance of giving the actual guidance yourself as opposed to letting the intestate statute work is that, at least in North Carolina, the intestate statute is often not what you would actually want. It's an attempt by the state legislature to treat people fairly. If you have any sort of estrangement or a unique family situation in your family, that may not be what you want. You may want to gift it to your chosen family, not to your blood family. So if you die owning real estate, let's say you're married, right? Regardless of whether or not you have children, let's say you have a blended family. Husband comes in with 2 kids of his own, wife comes in with 1 kid of her own, they remarry, and the property that they live in, the house, it's grandma's farm or something, they are living in a property that is owned by one of those spouses. Title to that real property is not going to go to the surviving spouse. It's going to be shared by the kids and the spouse. So you've now got stepmom and kids co-owning real estate together. Add into that, if any one of those children is a minor, we've got a problem. We now need a guardianship to deal with the ownership of that land or the disposition of a bank account. So it just creates a lot of complexity that's really not necessary if you just had really even a simple will.
Yeah, absolutely. Actually, one of the questions that I wanted to ask you was, and you have touched on it already, but if there's anything else you want to add, is how does having a will reduce confusion and stress and conflict among people? And I know that you've touched a little bit on this, but I'm sure that there are endless examples.
Well, yeah, I mean, you think about a situation where I'll have clients who have 2 kids and they are, live down the street from one, they take care of their grandkids, and then there's another child that they have not talked to in 30 years. There's been an estrangement, and maybe they would like to leave something to their grandkids that they see all the time and not to that child. You've got to do that affirmatively. There's also, it just gives a really clear roadmap in terms of what is supposed to happen, but also who is supposed to do that. So we don't have siblings all angling for like, well, I want to become the executor. First, spoiler alert, being an executor stinks. It is a thankless job. It is an important job, but it is not something anyone should be like, me, please let me do it. You really want to be appointing the child, friend, neighbor, cousin, whoever is the most suited for that role. It is a detail-oriented role, at least under North Carolina statutes. It requires some really high-level thinking of like, how am I going to treat everyone fairly in this whole process? But then also some real deep, detailed thinking. So you want to appoint people that you trust, not just whoever's left because you didn't make an affirmative choice.
We may have I know the focus of this is really about why to have an estate plan, but I'm thinking that we probably have some folks who are tuning in who know that they are named, or maybe they don't know, but they've just realized that they're going to be handling an estate. They're the executor, and they don't have the time. They're scared to death of it. They don't know where to start.
Yeah.
Is there action that a person can take if they truly cannot or do not want?
Yeah. I mean, as we've all learned as you grow up, you can't make anyone do anything they don't really want to do. So you could appoint someone to serve as a fiduciary in any role, under a power of attorney, under a will, under a trust, whatever. Just because they are appointed does not mean that they are required to serve. They might feel a moral or ethical obligation to do so, but they do not have to do it. That does not mean that they can just pretend like they don't have anything to do. They need to then affirmatively resign or renounce the appointment. And that's usually a 1 or 2 page document that I draw up that says, we don't even need to give the reasons. They do not want to accept that appointment, and therefore the next person in line is appointed, which is a great segue to something that people don't think about when they do these wills on their own. Having a catch-all to appoint someone in the event all of the named individuals fail to serve. We always include some sort of language that says, if none of the foregoing can serve, then this person can appoint someone. Also, people tend to forget that this is sort of like a living document. Like, you need to be reviewing these every so often, because I will have people who come in, oh yeah, I made a will back in 1978. It's still on carbon copy paper. I flip that very thin paper over and I say, okay, you've appointed Johnny in this role. And they're like, oh, Johnny died 20 years ago. I'm like, okay, you probably want to update that. Well, after Johnny, it was Julie. Oh, I haven't talked to her in 15 years. And you're like, okay, well, maybe she's not the person you want to appoint. In 1978, those were the right people. But they may have died. You may have a different relationship. Your kids may have aged into the role. They're no longer 14 or 12. They're now 50 and they could take it on. You need to be thinking about these things kind of proactively. And so what I generally tell clients is, you should look at it every 3 to 5 years, ideally, or in the event of a major life change, health diagnosis for you or a loved one. One of the people you've appointed or a grandchild might have special needs or something. The birth of someone, the death of someone, you win the lottery. Wouldn't that be nice? Knock on a lot of wood. Any of those big sort of life-changing events, you should at least look at it. Sometimes I have clients who call and we have a 30-minute phone call where I walk them through. Here's the plan. Yep, that's still what I want. Great. See you in 3 years. Other times I walk them through it and they're like, ooh, yeah, I don't own that business anymore. I probably don't want it. I can't give it to whomever. I own something different. We need to update your documents then.
Yeah. Thank you for going over that. What do you think? And I have in my head, what's the biggest misconception? But I think there's a lot of misconceptions. What are the most common misconceptions that people have about estate planning? And while you're answering that, what are some of the biggest fears that people have that prevent estate planning?
Biggest misconceptions are that I don't have enough assets to deal with, so I don't need a will. That's not true. I like to think of it as an insurance policy. You're paying money up front to make things way easier for your family on the back end. And frankly, sometimes the people with less benefit more from doing that, because we don't have the money to be spending on the back end. We don't have the money to be fighting over it. Or it's like land, it's family land, it's farmland, etc. The biggest fears, people do not like talking about death. I've gotten over that in my job, and I have to say I try to make it as lighthearted as we can. It is not always a lighthearted conversation, but it doesn't have to be this really morose, grim thing. There are also people who are superstitious that if we talk about it, it'll happen. I sort of like to think of it from an opposite perspective of like, well, now it won't happen because we've already taken care of it. But those are the big ones. Or just, ooh, it's hard to think about who should get this business. Okay, well, you better think about it, or someone's going to have to figure it out while they're grieving their mother, their friend, their grandfather. None of us are getting out of this alive, so you might as well do some planning while you can. I guess the other thing that comes up, it's not so much a fear, but something that I often see is people have been so afraid of doing it for so long, and then they get really sick. And now we've got not only do you still have to make those decisions that you could have maybe taken a couple of weeks to think through, I tell them, let's sit in the ick. Let's sit in the ick for like 4 to 6 weeks. And then you don't really have to think about it, but for 30 minutes every 3 years. And you're like, yep, that still looks good. I don't want to look at it again. The people who call and they're in hospice, or they are stage 4 and they are doing a lot of traveling now to Wake or Chapel Hill or Duke or somewhere, those are way harder because it's pressing down upon you, and you'd rather be focusing on your care or your quality of life. And now we're squeezing this task in at the end. I've never had a client leave the meeting and tell me they feel worse having done this. Never once. Every single one says, I'm so glad this is off my to-do list. I feel so much better. And that's part of why I like this job is it's the few lawyering jobs where I get to have happy interactions by the end, and I am helping someone
Yes.
in a process. So,
well, I know I can personally attest to how freeing, being peaceful it is to finally put my signature on those documents. And it was, in my household, it was, we need to do this, and we never did, and years went by.
It's this annoying scratch in the back of your head that you keep thinking about.
Yeah.
And then you just have it off your to-do list. Woohoo.
Yeah. And it feels really, really great. And you're right. That we started this by asking what is the biggest gift to your family, but it is also the biggest gift to yourself.
Yeah.
So thank you.
Never once have I had someone say I hated that experience. They have always said, I'm so grateful I did this, or I feel so much better, or I'm so glad that's already taken care of. Now I can work on my, my garden or something.
So I'm hopeful that we encouraged at least one person who's listening to this to say, it's time. It's time. I'm going to rip the Band-Aid off. I'm going to get this done. Where do they start? How do they find an attorney? What is this usually like?
I'm always cautious of Google reviews because I think people only review when they have 5-star or 1 stars. I would talk to friends and loved ones that you trust in your community about who they used. You will get a real response. Yeah, they were great. He was kind of weird, but the job got done, whatever. And you will know based on who your friends are, who the people are that are best suited for your personality. ACTEC, the ACTEC website, ACTEC, those are highly certified estate planning attorneys. Not everyone is one. I'm not one. I'm not eligible yet, but that's a place to start. But I think friends and family is really your go-to network.
And I will just let everybody know that the Four Seasons Foundation team, we are not attorneys. We do not give any kind of advice, but we do work closely with attorneys, CPAs, financial advisors in the community. And if you need a referral, you can always reach out to us, and we are very happy to help kind of point you in a direction that's beneficial to you and it suits your comfort levels.
And if you don't get along with that attorney, that is fine. We're all friendly. We can give you a referral to someone else. Just get it done.
Koral, thank you so much. This was helpful information. We appreciate it. And again, thank you to the Winkle Law Firm for making these conversations with the Care Navigator possible. Thank you.
Bye, guys.